Ready, start. Attempt on part of the magisterial court in such situations should be to strike a balance by putting one hand on right to speedy trial of an accused as embodied under Article 21 of the Constitution of India and the interest of the prosecution and society on the other hand. Full stop. A close reading of provisions of section 437 within bracket 6 of the code comma prima facie would show that a duty is cast upon the concerned magistrate to see that the trial of an accused is concluded within a period of 60 days from the first date of taking evidence. Full stop. The magistrate is obliged to make all possible endeavors to see that provisions contained in section 437 within bracket 6 of the code are complied with in its true, letter and spirit. Full stop. To that extent, it appears that a right accrues in favor of an accused to tell the court concerned that the trial has not been concluded within 60 days from the first date fixed for taking evidence for no fault on his part, and therefore he should be released on bail, maybe at that stage, there is some discretion vested in the magistrate to refuse bail for the reasons which the magistrate may deem fit to record. Full stop. Such reasons cannot be routine. Full stop. Such reasons have to weighty enough to outweigh the right that accrues to the accused in first part of subsection within bracket 6 of section 437 of the code, which appears to be drawing force from article 21 of the Constitution of India. Full stop. The words single inverted comma, any case, single inverted comma close, appearing in subsection within bracket 6 of section 437 of the code point at the legislative intent to make that provision applicable to all cases which are magisterial, tribal and non-bailable. Full stop. Legislature has not drawn any other distinction for applicability of subsection within bracket 6 of section 437 of the code. Full stop. In comparison to that, the provisions contained in section 167 within bracket 2 within bracket a within bracket first and within bracket second of the code provide for grant of bail in event charge sheet is not filed within stipulated time. Full stop. The provision is aimed at expeditious conclusion of investigation. Full stop. It also protects the liberty of an accused where the investigating agency fails to conclude investigation and file charge sheet within a stipulated time. Full stop. Since the accused gets arrested on basis of allegations of offense, the legislature has deemed it proper to protect his interest by awarding to him a right of bail, irrespective of nature of offense if the charge sheet is not filed within stipulated time limit. Full stop. That right has been held to be absolute and indefeasible. Full stop. The parameters contained therein cannot be wholly employed while dealing with an application under section 437 within bracket 6 of the code, since they both operate on different planes. Full stop. Even the language employed in both the provisions is different. Full stop. Whereas, it gives discretion to judicial officer to refuse bail under section 437 within bracket 6, it leaves no scope for such discretion under section 167 within bracket 2 of the code. Full stop. So far as question number 6 referred by the learned single judge is concerned, we state that decision of a coordinate bench of equal strength will have a binding effect on another coordinate bench as it lays down a principle of law rather than a statement of law in context of the subject matter. Full stop. So far as fundamental right of an accused envisaged under Article 21 of the Constitution of India is concerned, insofar as it relates to a speedy trial, the same cannot be pressed into service wish. The right of an accused accruing under section 437 within bracket 6 of the code. Full stop. Because The right of the accused under section 437 within bracket 6 of the code is altogether different than one envisaged under Article 21 of the Constitution of India. Full stop. Section 437 within bracket 6 of the code takes in its sweep only the right to speedy trial, whereas Article 21 of the Constitution of India has a very wide connotation. Full stop. If the answer to any one of the above referred fact situations or similar fact situations is in affirmative, then that would work as a fetter on the right that accrues to the accused under first part of subsection within bracket 6 of section 437 of the code. Full stop. The right accrues to him only if he is in custody during the whole of the said period, as can be seen from the language employed in subsection within bracket 6 of section 437 of the code by the legislature. Full stop. It would also be relevant to take into consideration the punishment prescribed for the offence for which the accused is being tried in comparison to the time that the trial is likely to take, regard being had to the factors like volume of evidence, number of witnesses, worked workload on the court and availability of prosecutor. Full stop.